This is the Reason interview with Nick Gillespie. I'm Billy Binion, guest hosting for Nick. Our guest this week is Rachel Barkow, a professor of law at NYU and the author of the book Justice Abandoned: How the Supreme Court Ignored the Constitution and Enabled Mass Incarceration, which was just released this month. Barkow and I talked about the importance of the presidential pardon power, which is a controversial topic these days, after former President Joe Biden used it to pardon Anthony Fauci and members of his family, while President Trump used it to pardon January 6 defendants, some of whom were convicted of assaulting law enforcement. We also discussed her view that certain Supreme Court precedents around criminal justice are alarming for anyone who cares about the Constitution and individual liberty. And we finished by chatting about what it was like for her to clerk for Supreme Court Justice Anthony Scalia as a Democrat. And now, to the Reason interview. Rachel Barkow, thank you for talking to Reason.
Thanks for having me.
So you have written quite a bit about the presidential pardon power. And we've recently seen some controversial pardons from both former President Biden, who pardoned his son Hunter and issued some preemptive pardons for his family, Anthony Fauci, and others. And also from President Trump, who issued a blanket pardon for many January 6 defendants, including people convicted of assaulting police officers. So I think a lot of people on both sides of the aisle saw those acts of clemency and thought, maybe this power isn't so great, and maybe it's something we need to rein in. So first, I just want to start off by hearing your reaction to those two sets of pardons. Let's start with Biden. What did you make of him pardoning his son and also issuing those preemptive pardons? And what did you think, what kind of precedent do you think it set for the future?
Yeah, so I start by saying I am a fan of the pardon power. I think it's essential. I think we have to have a corrective for severe punishments and for unjust convictions. And at the federal level, the pardon power is the only game in town. There's no other way you can get your sentence reduced. We don't have a way to expunge records. So it's actually a really important thing that we have it. However, that said, it's only as good as the people who exercise it. So when you have presidents who look like they're abusing this power, I think people may tend to criticize the power when they really should be criticizing the person who just used it. I think so we have to separate those two things. And in the case of President Biden, I was shocked when he made the announcement that he would never give a pardon to his son in the summer, because I thought, that's insane. What parent would say that? If I had the authority to protect my child from punishment, I don't know that I would stake out at the outset, no, I would never do that. And so when he said it initially, I thought, there's no way he's going to keep that promise. Like, he shouldn't have said it. He should have just had no comment on the case, because honestly, I figured from the very beginning that he was going to pardon his son. And not entirely without some grounds, because I do believe it is true that Hunter Biden would never have been investigated or looked at if he wasn't the president's son. Now, having said that, you can look and investigate a lot of people and not find any criminal activity. But in Hunter's case, there was. And so he once they did that, once the case went forward, which, President Biden had said, yes, that's appropriate. Yes, I'm fine with that. Then you really do have to let the chips fall where they may. And that is why he said, I won't give the pardon. Now, fast forward to after the fact, he's no longer running. His vice president lost the election. And I think at that point, he thinks to himself, what am I, crazy? I'm not facing electoral accountability anymore. I'm going to save my son. He gave I felt an unpersuasive press release associated with it that I found completely unconvincing. And what I think he probably just should have said is, you know what, he should just stuck with I'm a father. I have to do this. I hope you'll forgive me. But, I'm going to say that that's going to come first at this point. But, trying to make the claim about, there was really, people like this wouldn't really be prosecuted. It was really stretched and forced. So I thought that was terrible. And I thought it was especially terrible because he made the announcement at the outset that he wasn't going to do it. So it looked doubly bad. From the beginning, he had just said no comment, and then at the end said, look, I'm going to do this for my son, I think we would think of it differently. But I think it all looked so political and just manipulative of the election. It never seemed authentic in any way, anything he said about it. So I think that just made it all the worse.
Right. And then he preemptively pardoned other members of his family, and then some political actors like Anthony Fauci. How do you respond to someone who says, it's already extremely hard to hold people accountable, especially, people in the federal government, and that preemptively pardoning these people may embolden future political actors and future allies of whoever is in the White House to commit crimes because they can, reasonably assume that they'll just be pardoned before they're charged.
Yeah, I mean, I guess on the question of whether it's set a precedent, I have to say I felt like the that wasn't convincing to me in the sense that I think once we knew that President Trump was coming back into office, he's not really a precedent guy. So whether it had happened before or not, I think would make absolutely, zero difference to him in deciding who he would give a pardon to and how he would exercise it. So I think we were already in a landscape where we were going to see outrageous pardons in the Trump administration. So I was less kind of worried about it as a precedential matter and more just, what it does is it's such favoritism and uh, nepotism in the case of just, picking out your siblings. The thing that bothered me the most about Biden's pardon record is this would look entirely different to me if we had seen 4 years of him showing concern for how awful it is for anyone to be investigated by the federal government. Because essentially what he was saying is I can't put my family through this. I can't put them through investigation, even if they are innocent, because unlike Hunter, who, had a conviction, his, for all we know, these are just innocent people. And he just didn't want to see them the targets of a retaliatory Trump administration. But, I think if you were asking yourself as the leader of a country, what does that tell me about the federal investigative process? What is that like then for regular people? Like, if you're just thinking about it in terms of your siblings and their spouses, I would hope you take the next step and say, gee, I bet it's pretty awful for anyone to have to marshal resources to defend themselves against a federal prosecution, and maybe take a deeper look at how this process really harms all kinds of people. And instead, what we saw for most of his presidency, this was not a person who was generous with the pardon power. He had one of the stingiest records up until after the election when, he kicked it into high gear for legacy purposes. But up until then, he had released almost nobody from prison. The federal prison population grew under his watch. He didn't keep any of his promises really to try to pursue big reforms. So this wasn't exactly somebody who showed any kind of awareness or sympathy to what the federal criminal justice process is like for most people. And so for me, what I didn't like about it, less the precedent, going forward, what other presidents will do, and more just the fact that it just showed how unequal it looks to have a president just kind of pick out, oh, who do I know that might be harmed by this? And that's not how the pardon power should be. It can't just be, I happen to know some people that are affected. I want to protect them. You need a process in place for regular people. And the thing is, regular people filed petitions. He had petitions that were filed that went through this insane process that we can talk about of vetting by the Department of Justice, where it's almost impossible for you to get a positive recommendation for a pardon. And yet we had them. We now know that because there's been a leaked communication between the pardon attorney and U.S. attorneys, where the pardon attorney says, hey, look, first of all, don't blame me for the ones he granted at the end, which we can also talk about for some drug offenders that he did kind of in bulk without any vetting. She's like, don't blame me for who went through that because I sent over vetted applications that he didn't grant. So there were people who went through, they dotted all their I's, they crossed all their T's, they made it through this insane vetting process where the Department of Justice said, yes, you have an exemplary record. You did everything you're supposed to do. We, Mr. President, recommend you grant. And he left those sitting on his desk when he left office. And so for me, it's that disparity between the people who followed the rules and did everything they were supposed to do, got the positive recommendation, and they never got any attention, compared to what he did for his own family. And to me, that's unconscionable.
Right, and there's something you said just now that I think is really interesting. I think there's a real misconception that Biden was extremely generous with the pardon power, especially when the press around his pardons for people who are convicted of federal weed possession. Despite that, I think a lot of people don't realize they didn't release a single person from prison because there was no one in prison simply for federal weed possession. I'm not saying that's nothing. I mean, like having a federal criminal record, as you know, can be problematic in different ways and can have long-lasting consequences. But can you kind of speak to the disparity between some of the press around these, mass blanket pardons for drug offenders and what the actual practical impact of that was? Because I think that is lost on a lot of people.
Yeah, that was another pet peeve of mine. We can hit them all today. So when he made and I do want to separate out, there's a difference between the announcement he made earlier in his time in office that he was giving a pardon to the marijuana offenders, which, as you point out, is really more symbolism than anything else.
Right.
He made this big announcement. And he got what he wanted, by the way, because on social media, people were praising him and they thought it was amazing. But as you said, there was nobody in federal prison for marijuana possession. So he didn't release a single person with that edict. And actually, he also didn't clear that many records because as of the last time I checked, only like 200 some people had applied and submitted the paperwork to get the pardon certificate, because when he makes the announcement, that doesn't just do it. It's not like you can just go walk into a job and be like, hey, it's like that scene from The Office where Michael says, I declare bankruptcy. Like, it doesn't work like that. You actually have to go get your certificate of pardon. So you need to file paperwork with the pardon attorney. And as I said, the last time I checked, it was somewhere around 250 people had done it. So that's it. That whole big announcement basically amounted to just 250 people who got the pardon, and they were already out of prison. So, now they just have that, they can, show that to employers or other instances where it may matter that they have a conviction. Then the other thing he did that was more significant was as he was leaving office, like in the last few days, that was a bigger drug announcement where he announced a commutation of what he called nonviolent drug offenders, where he gave them sentences that he said would be the ones they get today, had they gone through the process today, because we've had some reductions in federal sentencing. And that's an actual real, not just symbolic thing that, benefited a couple thousand people. That one has been criticized because he did it at last minute, even though there were many of us urging him from day one, yes, that'd be a good idea. Here's how you need to do that. He didn't take that advice. He did it at the last minute. And so there are some people in that batch that definitely don't meet anyone's definition of nonviolent. And, he's gotten some blowback from that.
Right. There was someone who was released who I think the ACLU recommended, right, who had he had been convicted also of murdering someone or of taking part in a murder, and he received a sentence commutation and will be out in the summer. So that's what you're referring to, where essentially it was kind of clumsy.
Yes.
And right.
Clumsy is a nice way to put it.
Yeah, I thought about that. Right. Yeah, that's a sanitized way, I suppose. And then I would like to hear also what you thought about speaking of blanket pardons, that, essentially granted full unconditional pardons to people who committed, a range of offenses, Trump's January 6th pardons. I think that there is a real, another misconception that, only the nonviolent offenders were granted full unconditional pardons, which simply isn't true. I think 14 people were issued commutations, and he said he's going to think about, do more research into pardoning them. But there were well over 100 people convicted of violent felonies, including against law enforcement, who received full unconditional pardons. And
that was pretty outrageous. So I knew I think we all knew that he was going to do some exercise of his clemency powers in favor of January 6th participants, because he said so when he was running for office. So, that was kind of on the table. It was part of the campaign, but he never said he was going to do kind of a big blanket grant. And, there were suggestions there might be some individualized reviews so that you could separate out the kind of the people who kind of went along for the ride and they had been charged with trespass. And, you can kind of understandably kind of get that there'd be some sympathy for someone, who doesn't engage in any acts of violence. They just kind of find themselves in the moment.
Right, chanting like you caught on camera chanting USA or whatever.
And that is not what he did, though. I mean, he's got people who struck law enforcement officers, people who engaged in serious property destruction at the Capitol. Like, these are very serious charges. Um, and he made no pretense, that he did any kind of vetting or individualized review. So, in addition to the fact that you had people who committed really horrific acts that day, they were also people who had really serious records. And so, when you go through the pardon process, that vetting process I mentioned, it's not just that the pardon attorney is looking at the offense that the president is considering giving you relief from. They don't just look at that in isolation. They also say, okay, well, do you have any other record offenses that we should think about? Because, it is a real benefit to get a pardon. I mean, you kind of, when you think of who's fortunate enough to get this thing, you want to reserve it for people who, you really feel like they deserve it. There's nothing else. There's no other red flags that make you worried. He gave it to people who participated in January 6th who had really serious additional charges against them. And several have since been charged
Right.
with
I've
serious
noticed
crimes.
there have been a few people who have been rearrested
So
almost
I would say,
immediately.
yeah, and I'm not both sidesing it, because I actually think it's far worse to grant the big bulk January 6 people than it is to, give a symbolic pardon of marijuana offenders. But I will say the thing that the two presidents have in common that is really bad, is not using a process that makes
Right.
this benefit, this really important benefit that I think we need for a functioning federal criminal justice process, that makes it available to everyone on equal footing, so that everyone can apply. There's a way in picking who gets this that is fair and equitable, and isn't just, who he happens to see on Fox News, or who Biden's having dinner with, right? It's got to be something that is more procedurally regularized than that. And there is a process that both of them could have used, and neither of them did. And I will say, that was also a hallmark of President Trump's first administration. So, for anyone who was voting on the basis of how did this president exercise the pardon power, and I don't think there was anyone who did that, but
So probably like 10 of us.
yeah, if there was, I mean, all the red flags were there from the first time around, because under the first Trump administration, he gave 238 grants of clemency. Only 25 of those people had been vetted through the DOJ process. The
And
others,
for listeners who aren't super familiar with this, 238 grants, a lot, a little,
a
medium,
little, like
a little.
historically little. Yeah.
Okay.
Like, I mean, we've had, basically from President Reagan onward, the rates have been declining for clemency grants. It corresponds with a kind of tough on crime era, and the fear that if you give a clemency grant to someone who goes on to commit another crime, you'll have a campaign ad against you. That's like the infamous Willie Horton ad that was used against Michael Dukakis. The idea that, you just, why take a chance? And so the rates have declined since the Reagan administration. But even from a baseline of very low clemency rates since that time, Trump's were even low with that as the benchmark. So he had very few his first term in office. Obviously, he has more now. So it's important to note it's not just about the rate; it's who's getting it. But his January 6th bulk grant obviously got his numbers up on day one. So I would say you want to look at not only how many, but who, and what's the process. And really, the process criticism is the one that really worries me, because I don't like our current process. I think there's flaws with it, but you have to have some process in place that doesn't just look like favoritism and nepotism and, who has access. That undermines everyone's confidence in government. And I think it goes back to your statement at the beginning, which was a lot of people think we should do away with the pardon power. And that's why, because who would want to keep a power that looks like it's just some kind of perk you give out to your friends that's not available to everyone? But, it shouldn't be like that. It doesn't have to be like that. It's just, that's what we've seen in, the last couple months. It's been a really rough stretch of time for the pardon power. I can't imagine, I can't think of a worse time in history for it.
Yeah, I'm interested to hear what was the historical kind of expectation for this power. Essentially, it's kind of king-like, right?
Yeah.
But I think, would you say that it was essentially put into power as a check on prosecutors and overzealous, prosecution of various individuals, or is that a misunderstanding of what it was meant for?
No, I think it's all those things. So I think it does come from the king's dispensation of mercy, right? We get the pardon
Right.
power from England, but when the framers talked about it in the Federalist Papers, they talked about it that otherwise we would have punishments that are too severe. So, they recognize they were actually, kind of ahead of their time in sort of anticipating either that or it's timeless, that the populace is always going to have some demands for excessive severity. So they totally knew that. That's why the Constitution is just filled with protections in criminal cases, because they knew, you're going to get a majority impulse to be excessively severe, and you have to have checks on that. And so the pardon power was designed to give the president the ability to do that in federal criminal cases. It sits right next to the commander in chief power in the Constitution. So it's like the prime location, right? Like if you were a power and you want to know where would I like to sit, I'd like to sit next to the commander in chief power, right? Like that shows how important I am as a power. And they thought it was really important. Now, the difference is that they did not envision we would have an explosion in federal crimes. I think it's safe to say they assumed, we would just have this little smattering of things that would be federalized as crimes.
Right,
And
and for context, I mean, as you know, the president has no power. The vast majority of criminal cases are in state court, and the
right.
president has no power to pardon someone in state court.
Exactly. Which is why, in the discussion these days where people are like, oh my gosh, all the January 6 people, they can just go out and start assaulting people because now they know the president has their back. No, not exactly.
Right,
The only thing he has their back on are federal charges. But
right,
if you go and assault somebody, absolutely that could be brought as a state charge. So it's a limited power in the sense that it only covers federal offenses. And the framers did not think we were going to have a big, expansive federalization of criminal laws. I think they were thinking kind of treason, sedition, maybe some piracy related things, but they weren't thinking like cross state lines with a joint. That was just not not the vision. But what we ended up with post Civil War was just an insane, we start to see an expansion of federal criminal laws, prohibition, there's another huge uptick. And then when you get into the modern era and the war on drugs and, thinking about charging what are otherwise had been local crimes, but if a firearm is used and the firearm cross state lines, all of a sudden that's a federal offense. That's when you start to get into this huge expansion of federal crimes. And then that's when the pardon power starts to look like a mismatch, because now you're also asking the president of the United States is supposed to be the one person who's supposed to make sure that none of those sentences were too severe. Like that is not a great government design, right? It's one thing if he just has to
right.
keep track of like a few things. And then the other thing that the framers thought they had in mind, that they definitely had in mind, was using the pardon power at times of unrest or rebellions to kind of look, let's have a reconciliation. Let's have a clean slate for the good of the nation. So, something like the Whiskey Rebellion, you have a pardon of all the participants in the Whiskey Rebellion to basically like, okay, we get you were upset. But, we're a new nation and we want to kind of start with everybody understanding that, people might get upset at times, but we should really try to move on. So you kind of, the Vietnam draft evaders, lots of pardons of them, kind of same idea, but kind of like a national healing idea.
Right.
That was with us from the very beginning too. So they did think it was going to be a check on severity. They did think it was going to be this tool that could be used for kind of national healing. And then I also do believe it was a way for the president to check the executive branch and its authority in cases. So it's definitely part of, that's why I think it's next to the commander in chief power, because it is the idea of, the president is the chief law enforcement officer. And if under the president's watch, you have people who are doing things wrong, or there's inconsistencies in the country, one particular district is just excessively severe, the pardon power is a good way to check some of those kinds of things. It doesn't have to be the only way. Obviously, if Congress was doing more of its job, we wouldn't put so much pressure on the president to have to use it, but it's an important failsafe. It really is. So I hope, the criticisms that people have, people just recognize it's important to have it, because no justice system will be perfect. And you do want to have mechanisms so that people who find themselves on the raw end of the stick in terms of criminal punishment, that they have another out. And so I definitely, we got to keep it. We just need to get people who understand its importance and want to use a process so that it is truly accessible to everybody and not just their friends.
Right. Yeah, speaking of, I covered a case a couple of years ago about someone who received a commutation from President Trump during his first term named Philip Esformes, who was convicted of various charges related to Medicare fraud. And essentially, his sentence was commuted by Trump. And then the Biden administration attempted to re-prosecute him for the charges that were hung, which also, to add another crazy layer to the story, a lot of people don't realize that in federal court, you can be sentenced on charges that a jury did not reach a conviction on, as a part of relevant conduct. And the judge was very open during the sentencing that this man, Philip Esformes, was being charged for conduct that the jury did not reach a verdict on. He was sentenced on it. He had that sentence commuted by Trump. And it was controversial, right? Because it was this major alleged white-collar scheme. And the Biden administration, after getting some controversy for re-prosecuting him, I think offered him a plea deal that allowed him to avoid more prison time. But I just kind of want to hear your comment on that sort of politicization of the pardon power as, we become so entrenched and society just feels like relentlessly partisan these days. And of course, there are always going to be people who receive clemency that I think, as we're talking about, whether it's, Biden's family or January 6th pardons, whatever, that people take a step away and say, ooh, I don't know how I feel about that. But at the end of the day, even these questionable grants, you're saying this is still something worth defending at the end of the
Yes,
day.
absolutely. And I think, there should be some, I there should be some respect for a president's granting of it. I mean, it is the president's power, right? And
Right.
and the check on it is that it's an electoral check. I will say I was disappointed there wasn't more of an electoral check on the way it was used in the first Trump administration. We haven't even scratched the surface of some of the crazy grants in that one. Because it was really it was a grab bag, and it was basically a lot of his cronies.
Right. Like his main the critique. Correct me if I'm wrong, but the critique that I mostly saw of his grants during his first term was like this Philip Esformes person. It was a lot of people because I think one of Trump's associates brought him Esformes' petition, and people were saying like, okay, but there are a lot of people who may be more deserving than this. Would you say that's fair?
Yeah, and I mean, and a lot of people he saw on Fox News, there were some people who committed war crimes that Pete Hegseth, for example, was really pushing for clemency grants when he was a commentator on Fox. And then, there's his cronies, the kind of Paul Manafort's, Roger
Right.
Stone's, or big vocal supporters of him like Sheriff Arpaio. Like, it was basically loyalists, cronies, henchmen, however you want to characterize it, people in his orbit. And then he had a few that kind of came to him through people he knew, or like associates that I wouldn't think of them as kind of his political operatives or his cronies or people he worked with all the time. And so some of those people were regular people. So you've got your kind of Alice Marie Johnson, for example, is someone who
Hmm.
came to his attention through Kim Kardashian. So she who just happened to hear of Alice's case through public advocacy efforts by various people who were pushing for Alice to get relief, but like regular criminal justice reform types, not celebrities. But it caught the eye of the celebrity who then used her access to the president to help get relief for Alice. And then once he gave the grant to her, she was super grateful, as anyone would be, to get a clemency grant. And she was very grateful and effusive in her praise of President Trump, and I think he likes that. So he liked Alice. And I think that meant that Alice could make recommendations. So, it's kind of, so then we got a couple other people that I would put in the category where you look at the list and you're like, wow, how did that person get there? And then you kind of go backward and you realize, oh, I think they might have known through Alice, a way to get in. But that just can't be how you run a clemency operation. But once you do get grants, I think it's important to respect it. It is supposed to be that if a
Right.
president has said, look, I don't want to see this person suffer punitive consequences for this conduct. I think the kind of the recharging in the case that you mentioned, I find that disturbing because I do think
Right.
the idea, you should have a little bit more respect for the prior grant. Now that's different, I will say, than a state prosecutor who may have independent jurisdictional grounds to bring charges that, maybe the reason they didn't in the first place is because they thought, oh, okay, well, if the feds are going to deal with it, then I won't. And once the federal one goes away, I do think it's legitimate for a state actor to say, well, actually, I don't agree with that. I want to step in with my own jurisdiction. But, the federal government itself,
Right.
once there's been a federal grant, I think you take the L. you
Right.
take the L for the sake of kind of rule of law, consistency values. And you say, I would assume you'd want your grants to get the same respect going forward. I've heard some rumors President Biden gave commutations to 37 of the 40 people who were on federal death row, for example. And I've heard some rumblings of people saying, is there any way that, President Trump can try to reinstate
Right.
it? And I think it's the same, should be the same in both contexts. Like, no, you get the grant, you respect the grant, you move on.
Right. I just want to ask one more question about the pardon power before we move on. Is there anyone who really did it right, or really has any president that was like, oh, we really knocked it out of the park with clemency and showed how it's supposed to be used?
So I liked the Ford Commission that was created to deal with the Vietnam draft evaders, because he knew that he wanted to kind of think about a big categorical bunch. But he did want some vetting. And he set up a special commission to kind of do it, to take care of it in bulk. And what I like about it is that first of all, it's not a process that's run out of the Department of Justice, which I am not a fan of. I really think that the last person you should ask about whether there should be a clemency grant is someone who works for the Department of Justice, which was the same agency that prosecuted the case, right? It's just not an objective review. The DOJ, one of the first things they do is they ask the prosecuting attorney's office, hey, what do you think? And unsurprisingly, they come back and they say, what do we think? Why do you think we brought it in the first place? We think this person should get exactly the punishment they got. And so they say no to almost every single one of these. And that's not what you want. You want someone who actually can take an objective second look, because federal prosecutors get it wrong. They are sometimes too severe. They sometimes have tunnel vision. And so I like the idea of the Ford model because it created a commission that wasn't inside DOJ. We could talk about who should be on a commission in an ideal form, but I like that. And I like the fact that the idea was to efficiently process mass numbers of cases. Because at this point, I think that is what we're looking at the federal system. We do have a lot of federal crimes. We do have a lot of people. They need pardons so that they can get things that other people, they've long since served their time, but they need a firearm for a job, or they need to clear their record for a loan application, or, any number of things. There's no federal expungement process, which I believe we should have. But again, until Congress does its job and does that, you need a pardon. And for sentencing commutations, we don't have parole anymore at the federal level. So if we have an excessively long sentence, the only way you can get it reduced is you could try to get what's called compassionate release and ask a judge. But that's kind of luck of the draw, who your judge is, and it doesn't. It's a limited set of criteria. So, really the only catch-all that we have is the clemency power. And so it's really important. And there's a lot of people who are serving federal prison sentences, which means you need to be able to mass produce. You need to be able to do that in an efficient way. So I like the commission model. I like the attitude that says there's going to be a lot of these. We're going to need to do a lot of these. And you take that attitude on day one. So you don't just find yourself in your last days in office saying, well, history's going to remember me as the most miserly clemency grantor ever. Therefore, I need in a mad rush to start doing something nice.
Right.
And we've seen that time and again by Republicans and Democrats alike. It is a bipartisan problem.
And contrary to popular belief, you do not have to wait until you're leaving office to use it. You can use it all the time.
Trump did it on day one.
Right.
He had a really active day one, and that could be anybody.
Right.
I personally did not agree with his grants, but what he did show was that why you don't have to be he clearly wasn't afraid. And I think there's something to be said for the leader who isn't afraid either, because I think what we've really seen with clemency is just a lot of cowardice. They're just very timid. They're afraid of their own
Right,
shadow.
they're afraid of the political consequences of releasing the wrong person, the
Yeah.
wrong
And I
quote
think
unquote person.
instead, just go out there, be bold and say, like, you know what? Our drug sentences have been too long. And if it was in the case of Biden, it's my fault.
Right.
I was the person who pushed a lot of these. We've since changed our views, and it's time to fix those mistakes. And I stand by that. And, frankly, in the case of the death penalty, I'm very grateful that he did that. But, there too, I thought it should just be principled. I thought it should just be like, you know what? We don't ever trust the state to kill people. You barely trust the government to give you advice on vaccines. Well, you know what? You shouldn't trust the government to pick and choose who should die as a result of a criminal conviction. And so, as a blanket matter, I'm just going to commute everybody on death row. Once you start saying, well, these 3 cases are really
Right.
bad.
I will say I did think that was strange, because if you're opposed to the death penalty, then it would follow that you have to be opposed to it even in the cases that are a bit inconvenient, public relations wise. You know what I mean?
They were, don't get me wrong, they were bad.
The heinous crimes, absolutely.
But you know what? Look at the other 37, and let me just tell you.
Right, murder is pretty bad. Murder is pretty bad no matter, the circumstances.
Exactly. So, it's not like you look at any of those cases and you think, oh, well, they're bad cases. And so if you're against that, it has to be because you're against, you have moral opposition to the death penalty, or, in my case, I just think you can't trust the state to use a power like that. All right. The government is not, does not have a track record for me personally that gives me confidence that I want to give them the power over life and death, and since there's no reason.
A very libertarian argument.
It is for me personally. Because I will be honest, there are some cases where I would not shed a tear,
Right.
if something happened to the people who did some of these things. I'm not.
I would agree.
I understand people
agree.
who are, and I respect their views, religious or moral or otherwise. But I do think there are people who do things that are so awful that one could say in the abstract, yes, they deserve to die.
Right.
But I don't trust the state to be the entity that makes that decision. I just think that it's not. But whatever your kind of absolutist opposition to the death penalty is, it's should be principled and absolutist. So saying, well, I'm against it, except in these 3 cases where it was just so bad, I can't bring myself to do it. But the glass is 37/40 full as far as I'm concerned. And I don't want to leave the impression that I wasn't grateful for that one, because I was. And I think he did some other good things. Biden. I was glad that he gave the commutations to the people who were already out under the COVID relief measures. There were people who'd been released under Attorney General Bill Barr. They had shown they were living law-abiding lives. Like, it's just crazy to have them sent back to prison. It makes no sense. And so I was glad he did that too. It was a hodgepodge, disorganized mess at the end, with a dash of favoritism for his relatives. So, at the end of the day, it was not a laudable clemency record. And now we're about to see, I am quite certain, given the beginning of it, 4 years of something similarly awful.
Right.
Probably much worse, actually.
Well, if Trump or any future president is listening, they can know it doesn't have to be that way.
No, it
Just
doesn't.
listen to
You
Rachel
can have
Barkow.
a process.
Right.
I will advise. I'm the last Trump administration. I will tell you, I went to a meeting at the White House on clemency and possible ways to reform the process. Jared Kushner was there, Ivanka was there, and Kim Kardashian was there. So, it was all the experts. We were all there. And the idea was to say, there is a better way to do this. And, it didn't go anywhere, which is a shame. But it doesn't have to be a partisan issue. As I said, I think we've seen bipartisan failings on this front. But it can be fixed, and be great if he fixed it. Obviously the start doesn't make me confident that that's where we're headed. It doesn't look that way.
Well, on a more positive note, you have an excellent new book out, or coming out very soon.
Yes, thank you.
Called Justice Abandoned. And it looks at different Supreme Court cases that essentially led to the justice system that we have today. So I'm curious to start off talking about this. What do you think people most misunderstand about our system as it functions in practice?
I think the biggest, well, there's two. I'm having a hard time choosing. Can I give you two? So
Please.
so one is that the system that we have is keeping us safe. So I think one fundamental conception is we have to do all this. We have to lock up millions of people. We have to do it pre-trial. We have to put them in the worst prison conditions. We have to have a coercive plea bargaining system. We have to do all that to keep us safe. And the empirical evidence shows actually that is not true. And a lot of these things that we do have the opposite effect. It backfires. It makes things worse. It makes people more likely to reoffend. So, to the extent people think we need this for public safety, that is misconception one that I, kind of always want to get out there at the forefront, that this isn't about, okay, but you have to do it for safety. And then the second big misconception that I can't decide which is worse is that somehow it's always been this way, that of course you must have always been detaining people before they were actually convicted as soon as you thought they were dangerousness. And we must have always had coercive plea bargaining. Like all this stuff is relatively new. And for most of the nation's history, everybody agreed was unconstitutional. So, like the kind of idea that you need it and that it's always been okay. They're both wrong. And they're really, really relatively modern cases that condoned these practices. And they're terrible in terms of the outcome because it doesn't make us any safer. And it led to, all kinds of issues, including mass incarceration, having huge numbers of people incarcerated, creating a whole generations of people who are set up to fail for reoffending. It's racially biased. It creates a police state. It's been kind of bad across the board. And the cases themselves, the ones that I highlight in the book, the reason I pick these cases, like lots of people have Supreme Court cases they don't like. But my criteria was that these cases, you can't justify them if you're a textualist, you're an originalist, someone who wants to look, what did the framers think when, we passed the original Constitution? They don't pass under historical original understandings. And they defied precedent and longstanding tradition at the time that they were decided. So like they kind of fail all the major theories of constitutional interpretation. And then if you're just a purely results oriented constitutionalist, like, hey, I just want the decision that produces the best outcome, I argue they're bad for that too, because all of them have these counterproductive public safety effects. So they're really bad, these decisions when it comes to constitutional theorizing and justification. So, the only thing I think that keeps them alive is that people just assume they must be right. Like, people just don't second guess them. They just don't look at them. Or, it's a kind of the principle of stare decisis in law that says you respect precedent just because it's been around for a long time. And so one of the reasons why I wrote the book now is that, we have a Supreme Court that says, it's not just about stare decisis and keeping precedents. If you think they're wrongly decided at the time they were decided and they have pernicious effects, it's fair game to reconsider them. And I submit these cases as good examples of things that should be reconsidered.
So we can't talk about all the decisions that you go through. People will have to read the book for that. But I wanted to focus on one that I think a lot of people are surprised when they hear that a lot of people think it's an issue, and that's coercive plea bargaining. When you talk to people about the idea that plea bargains could be coercive, I think they're shocked because the general understanding seems to be that that is not a trial penalty, but a discount.
Right.
If that makes sense.
Yeah. No, people think you're getting a bargain, right? It's in the
right.
name.
And they think you're getting a break. So can you tell us a little bit about the contours of that Supreme Court decision that greenlit plea bargaining in the mass sense? It had existed before that decision, but it essentially, rubber stamped it. And then can you talk about why you think it's a problem?
Yeah. So, I think on the problem front, I think one thing that's good for people to know is, first of all, a lot of innocent people plead guilty. Okay. And we know that from the people who have been exonerated by DNA evidence. So, even if you think, oh, everyone says they're innocent, like if what you need is like scientific proof, we have an innocent person, it's not their DNA, it's this other person's DNA. That other person admits, they committed, we have them. It's like clear, no one argues. In about 10% of those cases, there was a guilty plea. So we have definitive, and that is the tip of the iceberg. That's just where I can tell you, look, if you don't trust me that there's many, many more cases, in these we have scientific proof. So innocent people plead guilty all the time. And the reason that they do is because even if you're innocent, if you are facing a prosecutor that says to you, hey, look, okay, let's say you're being charged for, they're saying, look, we found drugs in your trunk. You're like, that just can't be. Like, that can't be. They're not mine. I want to go to trial. And the prosecutor says, look, if you plead guilty, I'll give you time served. So you've been in jail. So we're not talking about that chapter, but they probably were able to keep you incarcerated while you're awaiting your trial. So maybe they'll offer you a deal of like time served. The amount you spend in jail, you can go home tomorrow and go home to your family and your kids if you plead guilty. But if you don't, then we're going to trial, and I'm charging you with this 10-year mandatory minimum.
Right. And you're going to be screwed.
And so ask yourself, because you're innocent. You're like, okay, but I'm innocent. But it's not like the trial is this perfect instrument for assessing guilt and innocence. It's a jury, and you're not even sure what evidence the prosecutor has against you, right? Like, you don't know. They don't have to tell you at this plea bargaining stage. You have no idea. And you're not really sure about what the jury will find convincing. And you're risking 10 years versus whatever the prosecutor's asking to give you today, offering to give you today. It is totally reasonable for an innocent person to say, I cannot take that chance, right? And I mean, there are just so many cases of people that, I couldn't take that chance because
I don't think I would.
Right. I need to care for my child.
Right.
I don't want to take that chance because I want to be with my elderly parent who will otherwise die while I'm incarcerated. Or, I want to live to see whatever it is. These are not bargains. These are threats. They're coercive threats that make even innocent people plead guilty. So, that's one group of people. But even guilty people, even if you say, oh, but the guilty people, they're getting a deal. No, not really. Because the Constitution gives everyone a right to have a jury trial when they're facing greater than 6 months of punishment, right? Like, that was a bedrock. Again, like, if you kind of go back and you read founding history, the jury was absolutely central to the framing of our Constitution because they didn't want just government actors to decide your fate. They had this great idea. They're like, you know what? You can never be punished unless a jury of your peers, just regular people, come in and they make a decision about your case. So the jury trial was even before the Bill of Rights. It's in Article 3. Like, it's a
right.
big
And some
law.
of the founders, they spoke about it so forcefully in their personal writings.
Yeah, there's no doubt. No one can make a colorable argument that, like, oh, the jury was an afterthought. Like, it's big deal. Okay. So this constitutional right that's in the Constitution, like, ask yourself how how you would feel if the government's like, yeah, freedom of religion, it's important, but the government, can say, yeah, but you can't get your benefits. You can't get your VA benefits if you're going to exercise a particular religion.
Right, like there will be some way in which you will suffer a harm if you exercise this right.
Right, like and so essentially, or you could look at it as a benefit. Yes, we are going to now start offering healthcare, but only for people who practice, their fundamentalist Baptist, whatever it is. Of course, the court would say, you can't do that. It's called it's the unconstitutional conditions doctrine, right? And you can't leverage constitutional rights that way. So for most of the nation's history, the thought of a plea bargain or a deal in a criminal case, no one thought that was legal. It still happened. Like, because caseloads were heavy, judges were like, oh my gosh, there's too many cases. What if we offered you a deal for you not to go to trial? And the prosecutors could offer it too. So you could sort of understand why it would happen, like, on the down low. Like, what if those were actually really deals because, they weren't really sanctioned. It was kind of just like, we need to clear the docket. And it was, we had the penalty on the books, but the idea was like, we're just going to give you a break if you plead guilty here today. So that was the system we had for most of the nation's history, and nobody thought it was legal. And once it started coming out into the open, there were these kind of various commissions that came to light in the 1920s. Were studying criminal justice, and it's like Casablanca. They're shocked to find there's plea bargaining going on here, and they criticize it. And at that point, we had about 70% of the cases were pleas. So people were pleading, which you can always plead guilty, right? You could plead guilty and just kind of hope the judge thinks you're showing contrition, and you'll get a break for that. But so we had about 70 to 80% of the cases at that point were the result of pleas. And so I think the expectation is everybody assumed they were going to get a break from the judge, or maybe the prosecutor was saying, look, I'll tell the judge it should, some kind of that kind of on the down low bargain. But no one thought it was legal. So when it comes to light, it's criticized. People are saying this is outrageous. How do we stop this? What do we do? And it's not until the 1960s that all of a sudden members of the bar, the legal elite, they say, well, actually, is it so bad? It is necessary for our courts to function. Like, we couldn't possibly give all these people jury trials. So let's just say it's okay now. Let's say it's okay.
Right, because you make the argument in the book that this is essentially about efficiency, right? It's not
Oh,
necessarily about
totally.
justice. It's just about we have a lot of cases that we need to prosecute, so we can't do that if everyone goes to trial.
Right. And they thought, and it's like it's everybody wins. You'll get a lesser sentence. We'll clear our docket as long as it's not coercive. That's a pretty big caveat. As long as it's not coercive, it's okay. And so they start kind of more openly recognizing it and saying it's okay. It's kind of like out and about as an okay practice. And the you start to get the Supreme Court starts hearing some cases that kind of bring it before, because the Supreme Court had never at this point heard any cases on plea bargaining because everyone thought it was unconstitutional. You wouldn't bring a case for something that you thought was blatantly constitutional. But now once you start getting members of the bar saying it's necessary, the Chief Justice of the Supreme Court says in a speech how the functioning of the courts depends upon pleas. So it's not a great environment for a case to go up to the court when your Chief Justice has already given a speech saying, gosh, we really need this. The courts can't survive without it. And so they decide a case that, it's an outrageous case on its facts. This poor guy, he ended up with a life sentence as opposed to his 5-year plea deal. So it's one of those cases you can imagine even.
And what was the crime? You talk about it in the book. Wasn't it check fraud or something
Yeah,
like that?
he's like got a check fraud thing. And, he's the guy's like, look, I'll either just kind of say it's okay for you to get your kind of regular, I'll think you get 5 years. But if you go to trial, I'm going to charge you as a repeat offender because he was a repeat offender. And you'll be under, what was like that
3 strikes law?
Early version of one of those. And you get a mandatory life sentence. Mandatory life. And this guy actually does go to trial. Like, I he probably should have taken the 5 years, but he goes to trial and he says, look, because what the prosecutor does is he then amends the indictment. Like, so first he charges him with the thing where he doesn't say he's a repeat offender. Then when the guy says, no, I'm not taking your deal, the prosecutor changes the indictment, brings the more serious charge. So it's a perfect case to tee up for the court to say, oh my, do you need a more explicit example?
Right.
And the prosecutor admitted that's why he did it. He's like, yeah, I did it because he turned down my offer. So
right, the audacity.
The court sees that's exactly what's happening, but they are so hamstrung by their efficiency concerns that even on facts like that, they say, it's two people reaching a deal, and we just kind of need to let this happen for the courts to function. They don't ever mention the unconstitutional conditions doctrine, which for sure you cannot do this under that. Like, the jury trial right is as important as any of the rights, maybe more so, where the court has applied this doctrine that says government can't coercively make you give up a constitutional right like that by withholding a benefit or, threatening a penalty. You can't do that. But that's what plea bargaining is. But the court says, well, that's, it doesn't analyze it that way. It never mentions it, doesn't think about it that way. It creates its own brand new box called plea bargaining. And it just says, it's okay. And it's okay because we need it for the system to function. So, it's just pure pragmatism. It's got no basis in constitutional text. It has no basis in the history of the document and what the framers thought of the jury trial or what anybody else thought. And for almost the entire history of the country, everybody who considered the issue thought it was unconstitutional. So it's this like just modern capitulation to efficiency. And, I think that and then once it becomes normalized, once the court gives it its official, like, okay, that's all right, in the early 1970s, somehow the already high rates of pleas get even higher. And, now we're in a territory of like 97, 98, 99% of all cases are the result of
Which
pleas.
is so
And that's why,
wild just
because
to think
once the
about.
court says, oh, it's okay. Well, of course, prosecutors now are like, great, you know what? We're going to really threaten you with the hammer if you go to trial. And then in addition to that, prosecutors think, what we should do? We should go back to our legislators and we should say, hey, can you give us more mandatory minimums? Can you give even more severe sentences? Because what we're going to do is we're going to use them to get people to cooperate with us. We want to use them as hammers. Like, it's all out in the open. Like, it's not like, you got to read between the lines and I've uncovered some secret. They're very blatant about it after Bordenkercher that that's what they're doing. And legislatures are like, yeah, oh, absolutely. Here you go. So nobody thinks that the sentences in statutes that are on the books, like another legal scholar compared them to the sticker price of a car. Like, nobody thinks when you go to a dealer, it's like, that's the price. That's just there to start the bargain. And that's true of these sentences and statutes. They were all now created with plea bargaining as the backdrop once the court says it's okay. So we have come so far from what the framers thought was necessary to protect individuals from the government. Because you need the jury, you need that group of people. And the thing is, people are too scared to exercise their jury trial, right? Because if they do, they face punishments orders of magnitude longer, and the risk is just too great.
What is the solution? Because if we were to get rid of plea bargaining, is there a chance that across the board, everyone just gets harsher sentences?
I don't think so, because I think the resource constraints would overwhelm the government. Like we actually couldn't really do that without building even more prisons, having even more, like it's what it is it's kind of like a clearance sale to like let all this stuff go through without the full constitutional cost. And a lot of these rulings are like that. They basically just let the government punish people on the cheap, instead of paying full price. And the framers wanted full price for a reason, which was it should be hard. You should want it to be hard for the government to take away somebody's liberty. You really, anybody should. And at this point in our country's history, I think we have enough people who personally either have been subject to investigation or prosecution or incarceration, or at least have a loved one or close friend who has. I mean, it's just gotten so ridiculously common that I think you see what happens when it becomes too easy. The government just starts using it all over the place, for things that don't need to be criminalized, things that don't need to be punished that way. So it'd be better to make it more expensive so that the government had to rationally think about, when do we actually need to use this tool? And you do need to use it sometimes. I'm not saying that you don't. I'm not even saying that you couldn't have there be judges who recognize when someone pleads guilty, maybe they get some kind of reduction. But what you can't have is a regime, first of all, where the prosecution does it, where, the same branch that's prosecuting you is making the decision about what deal you get. And certainly can't make an offer that anyone would agree is coercive. Maybe you can get some set discount that's not that big, but we're at the point now where people are being threatened with sentences 3, 4, 5 times greater than what their offer is. And you have to just ask yourself, well, if the prosecutor thought 5 years was okay for what you did, how on earth could you justify a life sentence for that? Like, really a life sentence for just deciding you want to have a jury make sure that that's right? Like, it's bonkers. But you definitely see among prosecutors today an attitude that they are really offended when people don't take their offers. They find that offensive and they view it as something that should be penalized. And so yeah, they and also from their perspective, if someone does go to trial, you can't like call their bluff and have them say, no, really, you're supposed to take the 5 years, because I don't want to give you a life sentence either. But once they've made the offer, they have to keep it, or otherwise everyone in the defense bar community will know, oh, this
Right.
person's a softie.
You're a
He'll
bluffer
bend
or
later.
whatever.
Yeah.
Yeah.
So you end up with these just horrible, I have many mentioned in the chapter, but they're all over the place in the legal literature, of just cases where you read them and you think, this is not justice. This isn't the way any judicial system should allow itself to operate. But the Supreme Court did, and it did it as a matter of case management. And I just think the Constitution is better than that. It should not just yield to case management. These are bedrock principles that, yeah, it's expensive. It's hard to go to trial, for sure. All of that is true. Well, so you know what, then maybe you need to find other solutions for these problems than just constantly saying, we'll just deal with it with prison.
Right. We see a lot of viral news stories these days about repeat offenders whose rap sheets may include dozens of arrests. And these tend to go, they tend to light the internet on fire. And the reaction, I think there's a pendulum swing. I think that there was a very tripartisan consensus, including during President Trump's first term, that our system is overly punitive often. And now it seems like a lot of people are saying, actually, it's not punitive enough. Like you might have seen during Trump's second campaign, Ron DeSantis called the First Step Act, which was a very sensible piece of legislation, a jailbreak bill, which is also just not true. The recidivism rates for people who were released under that law were very low. But But is there some truth to the idea that the system in some instances is not punitive enough? How do you respond to those stories?
Yeah, I mean, I think there are some kinds of crimes that are under-enforced. I think that, I think the kind of the most common example is if you were to look in like a high crime neighborhood in an urban community.
Those are the exact kind of backdrop of the stories I'm thinking
Yeah.
of.
So if you look there, clearance rates for solving homicides, for solving rape, for solving robbery, they're really low. Like, and often the average sentence for some of those crimes, I think some people might think they're too low for some of like the average sentence for rape in many places is about 4 or 5 years.
Right.
And then you compare that to, federal drug sentences, for example. Like, so the federal government is not the chief, as we discussed, is not, the place you go to get homicides and rapes prosecuted. That's local prosecution. And, local prosecutors make those decisions and states pay for the incarceration. And states, unlike the federal government, don't print their own money. So, states do have to think about how long sentences should be in a way that the federal government doesn't. And so at the federal level, they're not dealing with the most serious crimes. They're just dealing with the things that can be federalized. And so it's largely, it's mostly drugs, immigration, some firearms, a little bit of fraud, some child pornography. But notice what I didn't say. I didn't say homicide, rape, robbery, burglary, none of that stuff. That's all state level. So for the things that the federal government does, that's where politicians at the federal level just use it as like a symbolic statement about crime. And so federal crimes tend to have ridiculously long sentences
Right.
because they're kind of cherry picking. It's their only symbolic stance, and it makes no sense to give somebody who has sold drugs, especially like marijuana, which is legal now in some states but is still illegal federally. Give that person 20 years for selling marijuana when they'd get 5 years for rape. And that's everywhere. We just see that kind of mismatch. So I think it's actually accurate to say some sentences are not long enough, and also that some crimes aren't being pursued as actively as they should, because
Right.
it's also way easier for the police to just round up lots of people, for selling drugs on a corner or for some ticky-tack, trespassing in a public housing project kind of charge, jumping a turnstile, the easy ones, the kind of low-hanging fruit for law enforcement, as opposed to investigating homicides or investigating sexual assaults. Like, those are much harder. And so we have a lot of perverse incentives that mean that you have neighborhoods, they're over policed in the sense that they're getting, jaywalking tickets or, loitering tickets, but they're not seeing their clearance rates go higher for things like homicide and
And
rape
by
and murder.
clearance rates, this is the rate at which the police successfully solve
Yes,
a
solve
crime.
the
And
case. Yeah.
right.
So, that how to get away with murder show. I just always laugh with my students, like, how to get away with it. You just have to commit it in most places because most of them go unsolved.
It is actually, it's insane when you look at the statistics that if you commit one of these heinous crimes, there is sometimes a 50-50 chance that you will get away with it.
Oh,
That's
sometimes your
wild to
odds
me.
are even higher. Yeah,
Right.
right. It's crazy. And so, low clearance rates. And then even if you are convicted and charged in some places, the sentences, I think some people might find them to be, at least relative to how we're treating other offenses like drug crimes, I think they might find them to be too short, like for some sexual assault charges first. And it depends on, people have different views about different crimes. So, a little bit of that is got some subjectivity built into it. But it, corruption charges, people have different attitudes about how some of those things should be treated. But in general, I think we mostly have an over punishment problem in America. And I say that because we are the most carceral nation on earth. And I don't think we have the worst people. I don't think that we disproportionately have people, or even rates of violence, or even other markers that would suggest we should have anything close to the incarceration rate we have. And historically, we didn't. We used to look like other Western democracies. It's only since the 1970s that things really started to explode. So, it's a combination of a kind of politics of fear that really took hold. It is partially because of rising crime, but then that takes on a life of its own too. Like, people just start to get afraid even when crime's not rising. Partly it's these cases where the Supreme Court made it really easy for the government to kind of take that populist fervor and run with it with no checks. So you just end up in this irrational place. But some laws are better than others. Some make more sense. The First Step Act, the one that you mentioned that Governor DeSantis criticized that President Trump signed in office, that's a good piece of legislation. It has its flaws. And I certainly have things that I'd like to change about it. But by and large, that's a really great piece of legislation. That, for example, was the law that allowed people in the federal system. It used to be that if you were dying in prison, like literally dying, you had a terminal illness,
Right.
and you'd petition to get this thing called compassionate release, you had to ask your warden. Um, and the wardens were not saying yes. Not only were they not saying yes, they weren't even really processing your paperwork. Like people would die before they got an answer. So it was the subject of a lot of reports by the Inspector General of the Department of Justice that said, this is awful. This, you can't be this way. And one of the things the First Step Act fixed was to say, you know what, if you're not getting an answer from the warden, you just go to your district court judge, just go directly to the judge. And it's been so interesting to see what happened once that became an avenue for people, because the government still says no, by the way, when it goes before the district judge, the Department of Justice. It doesn't matter, again, Democrat, Republican, they just reflexively say no. But district judges started granting these once they saw them. Once they could see some of these petitions, they're like, yes, oh my gosh, of course, you're the last surviving caregiver for this minor child and your whole family. Yes, you should be released. Like, you've served long enough. It's fine. And so we've seen a lot of grants because of the First Step Act that never would have happened. And, those people, they're living law-abiding lives. It saved a lot of family and community suffering. It reduced sentences. It gave people opportunities to get their sentences shortened if they participate in certain programming that lowers their risk of recidivism. It was a good piece of legislation. It is not a get out of jail free card, but it's easy for politicians to say things like that because they
Right.
think it scores them cheap political points. And it does. It does play well with a public that, what average member of the public is going to research First Step Act grants and try to
Right.
figure out, was it good or bad? It's just easy to say they were letting people out loose. But, it helps that it was President Trump who passed it, because it's not like he's accused of being a softie. And so I think that gave it, frankly, a little greater protection to survive.
So I want to talk a little bit about you. You clerked for Justice Scalia, correct?
Yes.
Despite, I don't think you would describe yourself as a political conservative.
I am not, no. I am a Democrat.
What was that like?
It was great, actually. I actually highly recommend it. I think all people should expose themselves to people.
And you were not a conservative at the time either,
Oh, no,
correct?
no, he knew.
Yeah.
He knew, and he joked about it, and it was all fine. I think it's great. I think that that's one of the problems in our society today. We're so polarized, and people are
So polarized.
in their own echo chambers and bubbles. And I think it helps to hear how other people think about things. I mean, my year clerking for Justice Scalia actually shaped a lot of the ways that I think about criminal justice issues. Because what I realized is how much common ground there is among conservatives, liberals, libertarians. Actually, I feel like this is an area we should all agree, because what this is just a really big, inefficient, terrible government program that is making people suffer in a racially discriminatory way. Like, that should check everybody's box as bad. Like, nobody should want this. And clerking kind of helped me to see things that, views that I share with Justice Scalia. Like, I'm not a big fan of judicial activism. I really do think judges need to stay in their lane. I think you need
and for listeners, that's the idea that judges should be interpreting the law, not essentially rewriting it.
Yeah. And so you do need some boundaries on it. And so, I think there is something to saying, look, you got to stick to what the text says. You just can't go searching for meaning in legislative history. Like, he persuaded me. I think that that's right. And I think that it also showed me, there's some they were conservative values. I'm not sure they're still around, but the idea of federalism, and allowing.
Hey, here at Reason.
Yeah, I know you are very consistent. But I will say that the Republican Party, I'm seeing things from the Republican Party now that really, it's a shame, because me as a Democrat, clerking in that environment, listening to it, thought, yeah, you know what, you're right. Federalism is a value we need to appreciate. We need to let there be a plurality of views in America, and people can sort themselves in ways so we can stay harmonious and not just dictate for everybody, one set of rules. And I really believe that. And I believed it even when it was Democrats trying to impose various things. And, I believe it now when we have a Republican administration that's trying to do that. And I think what we lose when we don't talk to people who don't necessarily share our worldview, is trying to think of those neutral principles that we're willing to accept no matter who's in power. Like, I think now it's all just, no, we just need to get power. We just get power. Once we have power, we do what we want. And, that is not a recipe for keeping your democracy. Like, it is very bad. It leads people to want to take shortcuts in places that they shouldn't want to have, even float the idea of not obeying judicial decisions. Like, you start to see those little hallmarks out there of tyranny, and of disrespect for a constitutional order. And what I liked about my clerkship was there was so much we had in common. There was just that reverence for the Constitution, a reverence for making sure that our civic values are upheld. I didn't agree with every decision, but I understood that every decision that he made was coming from the right place, like from somebody who really did care deeply about America and the Constitution
Right.
and our system. And what I worry is that that's like a dying breed right
Right.
now. And if it goes away, you know, we'll all be sorry. Like,
Right.
you can't get rid of these protections. And part of the reason that what I was writing about in the book, one of the themes is, I get it. I get the temptation to just want to, we have this urgent problem and we need to kind of fix it, and you kind of get that vibe by the Supreme Court in all these cases, like, oh my gosh, crime is up. You got to let the police stop people even when they don't have probable cause. It's public safety. We're scared. And I think you miss the long view, which is when you start to allow all these little shortcuts and you ignore the Constitution here and you ignore it there. And you say, well, we have to do it because, we're just worried. You don't have a Constitution anymore. You just have the urgency of now, when you're supposed to have a document for the ages, even if it means you take some hits in the short term. And I just think we're living in a culture that doesn't appreciate that. And I think part of it is the lack of seeing all of our diversity as a good thing, worth getting to know people. Like I said, I had a great year. He was an amazing boss. He was funny. He was, at my wedding, so he came to my wedding. I married into
How
a
old were you
particularly,
when you did the clerkship?
so let's see. So it was 1990. It was like my late 20s.
Okay. So he's at your wedding.
I'm in a mid 20s. Actually, what I should say is I was 15. He hired me with like Doogie Howser when I was 5. So, I'm only 30 now. No, so I was in my 20s, and, he came to my wedding, and especially my in-laws, but, my family too, pretty liberal bunch. And they found out he was coming, and it was like, oh my gosh, how could you invite him? I'm like, why did I invite him? He's my boss. I love him. He's a great guy. And what was so amazing is he won everybody over. Like, they
Really?
talked to him, they realized what a great guy he was, how funny he is. And I just think that's like a little microcosm of like life. I feel like if people got off social media, they actually met people, they try to figure out what you have in common. And you realize there's a lot, and that we're just creating these weird silos. But I will always hope that one of the things we all had in common was our reverence for the Constitution and founding concepts of what our country is based on. And I'm most worried that we're losing that right now, because I think that, if people, get off the comments section, just take the time to actually get to know people. What you realize is, most people are good. They're coming from the right place. They just want a better future for, their kids and people that they love. And they just have different attitudes about how to get there. But we should try to find those kind of common things that we all have. And I don't know. It's a time in our country that I'm more worried than I have been, just because I don't like the discussions around the Constitution in particular, that have me a little bit worried. And there was nothing like that when I was clerking. So it's a
And to
different
your
time.
point, wasn't Scalia very close friends with Ruth Bader Ginsburg?
Yeah, that
They would
was
go to
a
the
mystery.
opera and
That was a mystery, not just because of their politics, though, I have to tell you, but it was also because of their personality types. Like, she was
what
a
was he like just as a person? I feel like Supreme
very
Court
jovial.
justices, really?
He was like jovial and like, telling jokes and laughed at things. He had a great laugh. Like, I mean, I still remember his laugh. I can hear his laugh. Like, just a very, kind of good natured, fun loving guy. And she was very reserved and a very kind of low talker. Like, you struggled to hear her when she
Right.
just spoke in conversation, when she wasn't on the bench with a microphone. And with long pauses, like you could do a Seinfeld episode.
Really?
On those pauses. They were crazy long. And so for me, the mystery was like their personality types were so different, but he made her laugh. She thought he was hysterical, and they had a lot of common interests, like, the opera. And her husband was like a gourmet chef. So think Justice Scalia liked that. He got a lot of good food dining with the Ginsburgs. And they had a good time. And they liked each other very much. So, it is a lesson for all of us that, you can put your politics aside and find out what you have in common. And I think you'd be surprised.
Was one of the reasons do Supreme Court justices seek out clerks with different views to kind of like hold their feet to the fire? And
not really.
So is that not a common thing?
He did, and I actually I love that about him, that he did that. He in his later years he sort of stopped. So when you look at the Scalia clerks, there's a kind of was one. It wasn't like he had it wasn't like 50-50. Like every now and then one would get thrown into the mix. But for some years it would usually be like there was one a year. And then it kind of petered out a little bit towards the end. So I think there was already a little bit of a tendency to stop doing that towards the end. And now, and he was really Justice Breyer, I think, also did try to do that. It was a little imbalanced in terms of the pool of law clerks, because just given law student populations, particularly at that time, there were more liberal than conservative clerks. So it'd be a little harder for the liberals, frankly, to do it than the conservatives. But for the most part, everybody just kind of picked their own kind. Justice O'Connor had a policy that if you didn't apply to every justice, she didn't want to consider you. So that was kind of her way of creating bipartisanship, because, her view, she was like, everyone would want her because she was right in the middle. And you didn't want to kind of limit your odds to just 4 justices instead of 5. That was when the court was split 5-4. And so she had said, if you didn't apply to everybody, she wouldn't consider you, which I also thought was kind of a great thing that she was doing. It was kind of the idea, like, you should want to clerk for any of us because you're here for the institution. These days, I have to report back, sadly, that especially since the leak of the Dobbs opinion, the opinion overturning Roe versus Wade, when that was leaked, since then, they were already in that vein. Like, they were already kind of going down the road of just litmus tests. They only want their own kind. But after that, it's been insane. Like, it's a shame. I think it's actually shameful. They should not be like that. But there you have it. If any of them were listening, you would benefit by having a law clerk that sees the world a little bit different than you. And you can find loyal, honest people who are not the same party that you are, that will not leak things, but will give you a different perspective. You should absolutely hire people like that. But that place has become a bubble, unfortunately, just like everything else.
You think so?
I think so.
What was it? I mean, what was your biggest, what do you think the biggest misconception is about the Supreme Court?
Oh, the biggest misconception. Well, these days, I think the biggest misconception is that it's all politics, because I really don't think that's the case. I do think that they, in their own minds, are applying law and using legal principles. But I think the misconception right now is it's all politics. So they just decide the result they want and they reason backward. And I don't think that is I certainly don't think that's the case most of the time. And I think even in the cases where that's not happening, I don't think, at least most of them, they're not doing it consciously. It's like operating at a subconscious level, because I think they all really do believe what they're doing is law. But they have that cognitive inability to see outside themselves to realize exactly how biased and reasoning backward they might be in certain cases, and I think, you certainly see it in these criminal cases that I write about in the book. It becomes pretty obvious. You kind of ask yourself, like, one of the cases, Terry versus Ohio, is the one that allows police to do stop, frisk, and question people just on the basis of like reasonable suspicion as opposed to probable cause. And when that case was decided, it was in 1968, and it was a presidential campaign year, and there were literally lawn signs all over the place, including in Washington, that said "Impeach Earl Warren," who was the Chief Justice, because the Supreme Court had decided a couple cases that were really politically unpopular about the police and their ability to do things. So they were literally on the ballot. Like, there were public discussions. Nixon, George Wallace, they were criticizing the court for their decisions. So when the case is being decided, do I think that those justices actually sat in their chambers and thought, damn it, there's an impeach Earl Warren side, I've got to decide for the police? I don't think that's exact. I don't think that's what he did. But I think it gets into it gets into your brain and you start to think about like, the police really need this power, like they're telling me they really need it. And you're like extra sympathetic to that argument because you're kind of operating in that world where those pressures are there. I think that's the kind of thing that I think is happening today. I think the justices don't really realize how much they are in the same world and environment with the rest of us. So they think they're objective and neutral when in fact they've also been consumers of Fox News and all the things they're hearing, and it enters their brain. And then when they think they're deciding objectively, I think they just are not fully aware of exactly how biased that is, which is why it would be good for them to hire law clerks and be around people who think about things differently than them. Because the only way you break out of that and recognize that in yourself is to talk to other people.
Right.
But I do
and
think
they call it a counter clerk, right? I mean,
yes,
wasn't that a term?
and that's why he
used to?
did it. He literally wanted, it's a little bit like when they talk about like historical examples of presidential advisors and making sure you have people who won't just be, yes men, that you'll have people who will contradict you. That was his model. And I think, so I think the misconception is that the justices are doing it deliberately and therefore they wouldn't care if they had someone who had a different view because they're just like, what's good for President Trump? I'm going to do it that way. And I don't think it's that. I think it is a lack of awareness of what you're not seeing and how might someone else view this. And obviously they have their colleagues and they don't all agree, so they see that. But I think they tend to view their colleagues over time as partisan. So I don't think they take them seriously. I think it's like, well, of course you'd say that because
Right.
you're in the tank for Clinton or whatever it is. And so I think, if you actually hired a person that was there to dutifully work for you, who is a loyal law clerk, but says, actually, I'm seeing this issue. Do you want
Right.
to see this issue? And I think that's valuable. I think that's valuable for anybody, in any work environment, in any
Sure,
context.
this is extremely transferable.
Yeah. But I do think we're losing it across the board in society. And it was never very popular at the Supreme Court anyhow. So I don't want to overstate it. It was a Justice Scalia thing that I think was pretty great. It was great for me personally, obviously. But I've tried to take that lesson on board in my own life. Like I really do make it a point to really try to understand things from a variety of perspectives. And I appreciate it. The other thing that I think the reason that he did it, and maybe some of the others don't, he knew he was really smart. It wasn't like he thought, oh no, I might get this 22-year-old who's going to hoodwink me into doing this thing that I shouldn't really do. Like, so part of it was also, have some confidence in your own intelligence. Like, you really think some 22-year-old's going to sway you in an improper way? Just get the perspective, but you're still the decision maker. And I think he knew that. I think he had enough faith in his own intelligence that it was no threat to him to have a different view out there. It was just valuable for him, to kind of take it into account and see what he thought. And I think they should all feel that way about themselves, but I don't think they do.
Fascinating piece of history. Rachel Barkow, thank you so much for talking to Reason.
Oh, thanks. It's been fun.